So first of all, we need to understand what is meant by listing of securities, and then what is delisting. So in this module, the objectives of the modules will be to make you understand the need for mandatory listing of the securities, and how it will protect investors interest, what is a listing agreement, what are the important clauses of listing agreement, and how the securities are delisted, and what is the procedure of the delisting, and how many types of delistings are there, and how ultimately both these listing and delisting of securities will be beneficial for the investors interest. So first of all, I will explain to you what is meant by listing and what is listing agreement. So any company which is a public company which wants to go for a public issue of securities has to list its securities on any of the recognized stock exchanges. Now by listing we mean that it has to enter into an agreement to provide a trading facility to its securities on the recognized stock exchange where the listing is done. So this is what is known as listing agreement, and there are number of terms and conditions of this agreement which are in the form of clauses which this public company or the person has to follow. In a short while we will look into different clauses of the listing agreement, where you will be able to realize that how much important this listing agreement is and how it will work for the protection of investors. So over here please understand this, that listing and delisting is dealt by three laws. It is by Companies Act of 2013, Securities Contracts Regulations Act of 1956, and also SEBI Act, which has a number of regulations for the delisting of securities. So all these three will be applicable when we are talking about listing and delisting of securities. So first of all, let us look at how the company goes for allotment of securities. So allotment of securities by any company is done under the provisions of the Companies Act, and the Companies Act under section 40 says that any company which wants to come up with public issue of securities has to make an application to one or more recognized stock exchanges for providing a facility of trading or dealing on the stock exchanges. So the stock exchange where this application has been made has to approve the dealing of securities there. Only then the public issue comes to a success, and only then the company can go ahead with allotment of securities. Now over here, when the company is making application to the stock exchanges, if it is making to more than one stock exchange, all individually all the stock exchanges they have to approve, otherwise company cannot go ahead with the allotment of the securities. Now when this money is received by the company, once the approval is given and the money is received by the company, then this money has to be kept by the company in a separate account, and it should not be utilized for any other purposes for the company, except for the two purposes, that when the shares are allotted or the securities are allotted, the amount will be adjusted against the allotment of the securities, and secondly, in case there has been any reason for which the company has to refund its securities, this amount will be used for the refund of the securities. Now over here it has to be understood that there may be number of reasons for which a public issue may not be successful. For example, minimum subscription. If 90% of the minimum subscription is not received, then the company will have to refund its securities back to the refund the amount back for the securities for which the application for allotment was made by the prospective investor. So once the approval has been given by the stock exchange for listing of securities, the company can go ahead with allotment of securities, and the amount which is collected by the company has to be kept in a separate account. This amount can be utilized only for the two purposes which are prescribed, and it cannot be used by the company for any other purpose. First purpose is that where there has been allotment of securities, this amount will be adjusted for allotment of securities. If there has been any refund, if any refund has to be made on any ground that for any reason the issue has been unsuccessful, then the refund has to be made, then this refund can also come from this separate account. So this is what the refund can be on many number of grounds. For example, for minimum subscription, if the company has not been able to get 90% of minimum subscription for its public issue, then the issue gets failed. So in that case, the company has to refund the money which it has collected for allotment of securities. So let us now understand the purpose of Securities Contracts Regulation Act of 1956. So the act was brought into force to meet a specific evil of undesirable transactions like speculations of securities. So, section 21 of SCRA 1956 provides for the conditions of listing of securities, and it says that that any person who is applying to the recognized stock exchange for listing of its securities has to comply with the listing agreement. So, this is what is the mandatory requirement imposed on the public companies for listing of securities by SCRA 1956. Let us now have a look at and a discussion on the important clauses of the listing agreement, and it is a heavy agreement, contains number of clauses. So, I will be focusing only on few important clauses of the listing agreements to make you understand the purpose of the listing agreement for the protection of the investors' interest. So, clause 16 talks about closure of transfer books, and it says that 7 days notice has to be given before a company declares its dividend or bonus, comes up with bonus issue or rights issue, or issues shares on the conversion of earlier issued securities. So, 7 days notice of closure of transfer book has to be given to the stock exchanges, and similarly if derivatives on the stock are also available, then also 7 days notice is required to be given. Clause 19 is about the board meeting. It says that 2 days before the board meeting, when the decision about buyback of securities or rights issue or dividend or conversion of securities into different types of securities is to take place or has to be discussed in the meeting, then 2 days notice should be given to the stock exchange. Clause 21 is about interest on debentures and redemption of securities. Over here at least 21 days notice has to be given to the stock exchange when the company is giving interest on the debentures or on any sort of bonds, or it is redeeming its debentures or any securities or shares of the company. So, 21 days notice has to be given to the stock exchange. Under clause 24, in principle approval has to be taken from the stock exchange. So, if a company is going for further issue of capital, it has to inform to the stock exchange, and it should give total fair, true and adequate disclosures in the prospectus document, and this information should be given to the stock exchange also. And also if the company is going for any reduction or arrangement, merger, amalgamation or any sort of compromise where a scheme has to be sent to the court or the National Company Law Tribunal, then the copy of this scheme or the arrangement has also to be sent to the stock exchanges at least a month before such kind of a transaction takes place. Under clause 28, if there is any change in the form or nature of or the character of the business of the company, then 21 days notice should be given to the stock exchange. Clause 29 says that a prompt notice has to be given to the stock exchange if there has been any change in the nature of the business, and if there is any change in the nature of the securities under section under clause 28, then also 21 days notice has to be given. Clause 30 is about changes in the directorate, etc. So, if there is any change in the directorship of the company or the change of the managing director or company secretary or auditors of the company, then prompt notice has to be given to the stock exchanges. Clause 31 is a procedural type of clause, and it says that without application made by the stock exchanges, 6 copies of the statutory and directors' annual reports, periodicals, special reports, notices, resolutions, circulars relating to new issue of capital, everything has to be given to the stock exchange, and 3 copies of all notices, call letters or circulars which are sent to the shareholders or to the creditors or to the debenture holders in connection with the scheme of the arrangement or reconstruction, merger, amalgamation, etc. has to be sent to the stock exchange. Clause 32 is about statement of salient features. Now, it says that the important portion or provisions of the balance sheet, profit and loss account, auditor's report, it has to be given to the stock exchanges, and if there is any new line of business which the company is undertaking, then the company will have to continuously disclose its turnover and income from such new activity in the annual returns separately for a period of 3 years from the date of this change. So, this is a continual disclosure requirement where the company is taking up any new line of activity or the business, and then company also has to disclose that whatever disclosures are made over here, they are as per the accounting standards which are maintained, which have to be maintained by the company, and similarly related party transactions, loans, advances which are made by the company, or if the company is making any investments, all this information has to be sent under clause 32 of the listing agreement. Now clause 35 is about filing of information, where the company has to file an information with the stock exchange showing the shareholding pattern, the details of logged in shares, depository receipts, patterns of the shareholding. This has to be informed. Then clause 35B was added in order to take care of e-voting facility for the shareholders, and because e-voting facility has been given mandated by the Companies Act 2013. So along with the postal ballots, e-voting facility has also to be provided to the shareholders of the companies. Clause 36 is about information for material events which happen in the company's operations, like there may be strikes or lockouts, or there may be closure on account of power cuts. So any type of such closure, if there is if it occurs, then the company has to inform the stock exchange, both at the time of the occurrence of this event and when this event comes to an end, this information has to be given. Besides that, if the company is beginning its commercial production, or if there has been any changes due to the legal framework, or there is a disruption in the company's operations due to natural calamity, or company has involved into any litigation, or there is changes in the prices because of the changes in the legal regulatory framework, if there has been change in the ratings of the company, all this material information has to be given to the stock exchanges, because all this information has a bearing on the performance of the company and their price sensitive informations. Then under clause 40A and 40B, the minimum level of public shareholding and takeover offer has to be informed. Rule 19 of the SCRA rules has made it now compulsory that every public company should have minimum 25% of the public shareholding. So in the case of companies where the companies they do not have this requirement, the promoters they have to offer their shares for sale, or they have to offer their shares to the public. They can do it in the primary market, or they can do it in the secondary market also. So all details have to be given, and if there has been any takeover offer for the company or acquisition offer for the company, the details have to be given by the company under this clause. Then clause 41 is a very important clause. It says that company has to give half yearly financial statement if there has been any variation in the revenue or total assets or liabilities of the company, or profit and loss in the consolidated financial results, and this variation is 20% or more from the last audited financial statement which was filed by the company. So if there has been a variation of 20% or more, then the company has to file half yearly financial statement also to the stock exchange. And clause 41 says that every public company should have a company secretary, and who should take care of the due diligence for the share transfer, and he will be the person who will be responsible for the compliance under the act. And clause 49 is the very important clause. Everybody knows about that this clause relates to the corporate governance. So over here, who are the CEO, COFO, who are independent directors, how the board of the company has to be constituted, how many independent directors, executive, non-executive directors should be there, and how the certification has to be done, what relationship directors should have the company, related party transactions, all such information has to be given under the corporate governance clause of clause 49, and the code of conduct has to be developed for the managerial personnel, and what is the internal control system, whether it is effective or not, all this information has to be given, and also an auditor's report has to be taken on the compliance of the corporate governance norms. So this has to be filed with the stock exchange. Clause 53 is with the agreements with media companies. If a company is having any agreement with the media company or any of its associates, then that agreement has to be disclosed. If there is any shareholding given to the media company, if is having any nominee in the board of directors of the company, or if there is a possibility of any potential conflict of interest, all this information has to be disclosed under clause 53. And then clause 54 says that a company should have a functional website giving shareholding pattern, the operations of the company, the business of the company, board of directors of the company, annual reports, last published annual reports. All such details should be available for the investors on the functional website, so that before applying for allotment of securities, they can look into the website of the company to make an informed decision whether they should invest into the securities of this particular company or not. So over here we see that all these agreements, all these clauses of the listing agreement, they are indicative that the stock exchanges want to have every information which has some bearing on the investors interest, so that all this information, any changes, continual disclosure is made by the company to the stock exchanges.